speaker tonight is Mr. Larry Morris, one of the best lawyers in the United States. In fact, he has been selected on an august list of one of the best 100 lawyers in America. He's from Alexander City, Alabama. He's always been a standout in everything he does. He graduated from Auburn. He attended law school at the University of Alabama, where he was president of the law school. He has been a city judge. He has been a legislator. He's been a member of the Alabama Trial Lawyers Association. He's also been the president of the Alabama Trial Lawyers Association. He has tried over 20 cases that I know of throughout the state of Alabama that resulted in verdicts of over $1 million. In fact, he's had at least 2 verdicts that I know of over $25 million. I guess all of you heard in nearby Gunnersville, Alabama, right down the road, there was a verdict for $25 million against Prudential Insurance Company for some type of insurance fraud. Mr. Morris is the lawyer who did it. His daughter, by the way, Clark Denny, is a U.S. attorney in Birmingham, Alabama. And he's going to talk to us tonight on the practical considerations of trying a lawsuit. Mr. Morris.
I commend you. I commend Alan for an outstanding program. I don't know of another facet of the law that y'all have not at least been exposed to. So when Alan asked me to speak tonight on certain things, he says, choose your topic, and I named about 4, and he says, done that, done that, done that. And I said, well, we got to go to practical considerations. Now, I don't know what that means, but I know this. It means I can deviate and go about where I want to go. So let me share some things with you that perhaps after 30 years of standing before juries in situations that I think that oftentimes that you take on large entities, you are the underdog oftentimes, and usually at least I get myself motivated thinking that that's the situation. Let me talk to you to start with about a couple of things that I would say to you maybe in the outline that you start with. Many of you, your relatives, your friends, are going to think at a certain point in time that they have a case, that they've been done wrong. They've either been injured as a result of a product, injured as a result of a neighbor, injured as a result of medical treatment. And so then you're going to be in a position to say, maybe you ought to get a lawyer. Let me talk to you about the first thing that's in the outline here that oftentimes is very difficult in today's society, and it does not bode well for us, for my profession. And that is, many times people walk into my office and make an appointment and sit down and talk with me or members of my firm, and they say, look, let me explain what has happened. And I sit there and I listen to them. And this is what I end up oftentimes saying to them: you've been done wrong. And you know, under the law, if you've been done wrong, there's supposed to be a remedy. You're supposed to be righted. It's supposed to be corrected. It's the way our system of jurisprudence was founded. But there's some other things that come into it so often, and that's the economic considerations. Perhaps the best example I can give you, and y'all have had a talk on medical malpractice. But oftentimes you'll see a hospital or an entity, and I'm not picking on them, I'm just throwing out that you'll have an entity where an individual perhaps has ended up with some injury, maybe some permanent injury that really just by any standard of care should not have occurred. But thank the good Lord, their injury is not grievous enough for us to take that case and spend $60,000 to $80,000 in preparation of a medical malpractice case because her injury would not warrant it. So one of the first things, is the toughest thing for me to do so often is in the interview of a client is when you look at a person and you say, you've not, the system should, the courthouse should be open to you. But economically, We can't afford to take the chance. And we turn the case down. Many times I've told clients, please go see another lawyer, get another opinion, and see if they'll do it. So the fact that a person says to you, based on your exposure into what you have done in these 21 or 22 weeks, and you'll be amazed. You're going to find out, because I can go in the grocery store and they'll say, hey, Larry, come here. I got this legal problem. It's not too much fun sometimes being a lawyer. So people are going to find out about you, and one of the things that you're going to be mystified at the system is sometimes the injury doesn't justify the money necessary in order to prevail. Another thing that you look at when trying to decide a case is whether or not the conduct of the defendant is egregious enough or wrong enough that would shock the jury. It's a practical aspect. Sometimes a person may not have been taken or may not have been cheated out of, but let's say $700 or $800. But when it's done on a repetitive basis, on a continuing basis for a period of time, that you're talking about thousands and thousands of dollars, was the result of the egregious conduct that was made by the defendant, then you can maybe perhaps afford to take that case, because the conduct of the defendant is bad enough. Another thing that you determine when you're evaluating a case is venue. Does everybody in here know now what venue is? Venue means the place where you're going to bring the suit. Venue is composed of a judge, and venue is composed of the people that are going to sit on this jury. Quite candidly, Madison County has a reputation of a very, very conservative venue. And that is, the juries are reluctant to reward or properly compensate an injured victim. Venue plays a big part in whether or not you feel like you can get adequate results for your clients. So venue is another thing to consider. And I don't mean that derogatory for Madison County, because I think that the scrutiny ought to be made in every case to know that what's being done is correct, meet, and proper under the circumstances. But it does play a part. We're fortunate enough to perhaps try cases mostly in most all counties in the state. The area where I live is a cotton mill town. Basically, Russell Corporation is a large corporation there that makes sportswear, and but the juries are comprised of blue-collar hourly workers, and generally they want to make sure that a person is adequately compensated. And in all fairness, and I can look at this august body here, you got some engineers that's going to sit on this jury, and they're going to analyze and technicize everything that ever comes out. So it's a difference, and that does play a part. And then here's the final thing when you're trying to decide whether to accept a person's case, to represent them under our sworn duty to the very best of our ability. And that is deciding in your own mind, will 12 people ever be able to agree that you're right and to the degree that you think would be fair? I promise you, no one has a greater appreciation of how difficult it is to get 12 people to agree on anything. It is, to me, the jury, I am in love with juries, because to me, for them to come down on the same side and agree on usually a fairly complicated set of facts, I get immense satisfaction out of that because I know how difficult it is. It's just very difficult. It's just, you know, it's just the most difficult thing that I know that you can do is get 12 people to sit there for a week and a half and listen to a set of facts where both sides are going at it pretty hard. And it's spirited. And for those 12 to then retire to a jury box, and all of them agree with me. I just think that's a marvelous concept of jurisprudence, and it's a very difficult and a very heavy burden, but that's one of the things that you have to make a decision as to whether or not to accept a case or not. Now, why did I tell that story at the beginning? And I'm going to skip over to number 6 in my outline, but basically the next thing is after you've decided to take the case, one of the cardinal rules y'all have heard all your life, and I've heard all my life, is never ask a question that you do not know the answer to. You see, the trial of a lawsuit, everybody in this room has a fear of court. I don't care who you are. The reason you have a fear of court is the unknown. Lord, everybody has got some skeleton, ever how tiny, is in the closet. It may be your third cousin. Half of mine are in the penitentiary, so I'm not worried about them. But what I'm saying, everybody has a fear of court. And here's what you don't know about court. Court is the grand finale of a play that has been rehearsed by both sides. They don't have the Perry Mason that stands up in the back and the lady says, "Oh me, I did it." That doesn't happen in civil court. Criminal court is different. But in the trial of wrongs, of civil wrongs, where you're trying to right a wrong for a person that's been injured or been mistreated, there's been depositions and discovery, and you've had all sort of talks about what constitutes discovery. But you see, the difference is this. The depositions, everything comes out in deposition, and then the lawyers weed through it before as to what's admissible in court and what's not admissible, and all the witnesses have already been asked the questions, and therefore they read their deposition, and when they get on this witness stand up here, they know the answers to the questions. So it's not this thing that we have a terrible fear. Now, why I even mention that? I mention it because of this. One of the most frustrating things as a lawyer is representing individuals who've been hurt and mistreated is when you sit there on Friday before you're getting ready to go to trial on Monday, and you're there and you're saying to them, "Look, your mother's life was taken by a person. He didn't mean to kill her. It was inattentive. He wasn't looking out. He was sleepy. He'd been driving all night with this 18-wheeler. He had to make a deadline on here. He didn't mean to do it. But $500,000, $600,000, $700,000 they've offered for your mother's life. When the trucking company has had a history of, this is the third one in the last 9 months, they've been a wreck with a fatality in it. That's not enough money. And they say, "Yeah, but I don't want to go to court." And they never want to go to court, and the insurance company realizes they don't want to go to court, and until you get to court, they're not going to pay what they ought to be paid, what ought to be paid. Most cases that are properly handled are settled on the courthouse steps. Y'all have heard that all of your life. The reason why is when that insurance company finally realizes that the people are willing, they're brave enough, courageous enough to go to trial, and they get there, they will pay on Monday morning. And I think every lawyer in here would tell you that that's generally the case, and that is correct. But the reason why is that people like me and you, and before I ever got in this business, my daddy was a welder. My Lord, I'd never seen court. I was scared to death. If I was in court, I didn't want my daddy to know about it. So you're afraid of it. But a play has already been rehearsed. So I say to you tonight, one of the practical considerations is do not be afraid of court. And let me tell you something else. Those things that are in your closet, and everybody has them, they don't come out in trial. They're not admissible. It's not a libel or a slander case where your reputation is placed on the line. It's a case where you've been run over by somebody who wasn't paying attention. And the way you operate your vehicle and the way they operate their vehicle are the admissible questions. Not whether or not you had a third grade school teacher who reported you sent you to the detention hall and made you stay after class and you got in a fight with her that happened 25 years ago, or whatever it is, it's in, everybody's got him. So I say to you, don't be afraid of court. I think a little bit about my favorite hero. Favorite all-time quote comes from General George Stedman. He was, truthfully, he was on the other side in the Civil War, not our side, but anyway, he said he was addressing his troops just for the Battle of the Second Manassas. I think that's what was been called in history books the Battle of Bull Run. But General Stedman apparently had a premonition about how this battle was going to go, so he addressed his troops and said, "Gentlemen, I want you to fight vigorously and then run away. As I am a bit lame, I'm going to begin running now." And see, that's the way people feel about court. They want to avoid it. And I'm telling you, I've come to you tonight and tell you, the booger man doesn't live in the courtroom. One other thing I'll say to you, judges treat people, they treat lawyers awful. Some of them do. But judges treat you wonderfully, and they should. It's your courtroom. It's a public courtroom where the public is invited. There ought to be justice in these halls, in these walls. And therefore, a good judge will treat you with the utmost respect. And he'll ride the lawyers, but he'll treat you. So I say to you, do not be afraid. Do not in any way be afraid of court, and don't let anyone intimidate you into being afraid of court. Let me share something with you that may or may not have been said. People often, we go before a jury, and one of the things we ask juries, and it's become a thing, and I know that tort reform has become a hot issue, and I know also that things like, I see these bumper stickers, stop lawsuit abuse. Let me tell you why the other side that you may not know. There are 7 things that occurs, 7 hoops that occurs before any money is ever paid in any case that the injured party and his attorney have to jump through to satisfy the judge, not the jury. I'm not talking about satisfy 12 jurors. When you file a lawsuit, a complaint is filed with the clerk's office, and you pay $107 plus whatever local fees you have. I think it's $117 up here, if I'm not wrong. But anyway, you file a complaint. The other side has 30 days to answer. And then the way they're going to answer the case is they're going to say, "Judge, dismiss this case. You don't state a cause of action." They file a motion to dismiss. That's the first hoop. Then after you've spent money and taken a lot of depositions, they file what's called a motion for summary judgment. The judge can throw it out. The Paula Jones case just happened. He threw it out, said, "You ain't even got a case. Spent all that money on depositions." So they go through summary judgment. Then after he lets you get to trial, you've got 12 jurors sitting in this box. You're halfway through trial and you say, "Your Honor, plaintiff rest." Plaintiff rest his case. Judge, they say, "Judge, we filed a motion for directed verdict." They ain't proved nothing. Judge got to decide that. Have we met all of the elements? That's 3 hoops we jumped through. Then a jury goes out and decides that we're right and rules in our favor and awards a sum of money. All 12 of those jurors. That's 4 hoops. The 5th hoop, then the judge gets to decide after that. Oh, the jury goes home within 42 days of that verdict. The jury goes home. Doesn't forget about the jury now. Judge can set that whole thing aside under a motion for new trial or judgment notwithstanding the verdict. JNOV we call it, or motion for new trial. You saw what the judge up east did with the British lady when they convicted her of murder. He set the whole thing aside and going to decide on his own. Judge has got that power. Then after that now, you've already got your jury verdict. You've jumped through all these hoops. They say, okay, Judge, we're going to appeal. Wait a year and a half. Goes to the Alabama Supreme Court. Year and a half goes by. Alabama Supreme Court now, that's the 6th ruling in your favor. They rule with you. They file a motion for rehearing. Okay, what about the motion for rehearing? Judge, all 9 of you judges on the Supreme Court missed it. There hadn't been any money change hands yet. We talking about lawsuit abuse? You jump through all those hoops, you're going to be right. You're going to be correct. And I will say, we just got one, our firm just got back one today from the United States Supreme Court. There's one other step I didn't even put in here, is after, this is a verdict in 1993. This is 1998, February the 17th, 1993, we got a verdict, and here it is, April the 20th, 1998. It's been to the United States Supreme Court twice. So we jumped through 9 hoops. So I guess what I would say to each of you tonight, there is another side of this story about any runaway verdicts or lawsuit abuse. Now, don't get me wrong, I think that lawyers have a sworn duty not to file a frivolous lawsuit, but I just wanted to share with you there is another side of that. You know, one of the things that kind of reminds me a little bit of along this line of a practical consideration, there are a number of things that, that lawyers can and cannot do in a courtroom. It's pretty interesting what they can't do, what they just will not do and should not do, and you get a mistrial. And what I mean by a mistrial, judge just takes the gavel, slams it down, says, jurors, y'all excused. We'll try this case another time before new jurors. This lawyer has said some stuff he wasn't supposed to say. Lawyers are notorious long-winded, as we all know. I can't help but think of the story they used to tell on Senator Heflin later in his career. He was renowned as a colorful character, and he could spin a tale, he could tell a yarn, he could tell a story about as well, and I'll never forget the story they tell is that in the twilight of his senatorial career about 3 years ago, he wanted to just kind of bring all Alabama, and he was giving a big speech in Birmingham, and he started up in the northern Sand Mountain, northern part of the state on Sand Mountain, and he went on and eased down into the pine growing country of South Alabama, and then over into the peanut farmers over in the Wiregrass, and then kind of ended up in how great Alabama was down on the Gulf Coast. And he kind of got long-winded, and he kind of started over, and then he started talking about how proud he was of Redstone Arsenal, and then he moved down into the steel mills of Birmingham, and then moved over into the textile areas of Alabama, and then ended back up at the Gulf Coast again. About the 3rd time, he was going to start this same trick around the state about how happy and how proud he was to have represented the state in the United States Senate. This fella raised his hand in the back and said, Senator, when you get back over there around Selma, how about dropping me off this time? And I kind of think that lawyers sometimes are in that situation, is that we have a tendency to be redundant, and we want to drive that point home and that force home when we're trying a case. But jurors amaze me on what and how they pick up things. They amaze me on what cases turn on and how perceptive they are. Things that we often deem important are just not that important. The toughest thing for a lawyer to do, I can tell you this, is when you do get surprised. When you're there and you think it's either your witness or the other side's, and you know the answer, and I think the test of a real lawyer is when you're standing up before a jury like this and they say, the witness says something and all those eyes cut right at you. And your legs go rubber and you can't, and you got to say something. And usually what you about to say is, yeah, I thought you were going to say that, you lying rascal. It's what you want to say. But it is very difficult to get back over to that table and do that. But that's the tough part of the lawyers, not the laymen that sit on a jury. You get a summons to go to jury duty. You get a subpoena to be a witness. You get a summons to be on a jury. People get off of juries. It's terrible. I've been practicing all 30 years. I wish I could ever get summons to be on a jury. I know they'd never pick me. But I just think it's the greatest experience, one of the true experiences in living that a person would have an opportunity to do. What do you do? What do you do? Well, you go up there. You're going to hear a judge say, you're going to raise your hand, and he's going to say, now, ladies and gentlemen, the lawyers are going to ask you some questions. They don't mean to pry into your private life. They don't mean to do any of that, but they're going to ask you some questions. We want to please answer them. Please respond to them. So when he does that, he's going to be up there, and he's going to say, okay, Mr. Morris, conduct your voir dire to the voir dire. Boy, you're going to say, am I a voir dire? What is that? It just means jury panel. But here's some things it's going to ask. They're going to ask you a number of questions. There's no right and wrong question, but you're going to be summoned to jury duty, and you're going to be on there, and you're going to be wondering, they're going to ask you some questions. And they're going to ask you things like, do you know the plaintiff? Any of you ever been a plaintiff or a defendant in a lawsuit? Real generic type things. Some of you are raising. There are no right and wrong questions. One of the greatest things that's ever happened to me, I was trying a case against a longtime adversary. He really thought that I was an outlaw, and I thought that he was a total crook. He was on the other side of this case. We were getting ready to try, and I don't mind. He was from Birmingham, and there wasn't a lot of love lost, and we had tried a lot of cases against each other, never friendly. We always had to try them because there was no settlement. And you know, sometimes when you do a little something good, it does come back. But I'm sitting out there in federal court in Montgomery, and the lawyer said, do any of you know Larry Morris? And this lady, two people raised their hand. This old lady, elderly lady, marvelous lady in the back, and a gentleman over here that I knew, and I didn't want him on this jury. Both raised their hands. So I said, the lawyer says, yes, sir, could you tell me about that? He says, yes, sir. He coached my son in baseball in the All-Stars, and I didn't like him. But anyway, so he sat down, and he thought, well, he's poisoned this whole jury. This guy couldn't coach baseball, and he wasn't fair with his son. He must be what I think he is, an outlaw. About that time, this little hand in the back goes up. He said, yes, sir, I know Mr. Morris. He said, well, how do you know Mr. Morris? He said, well, he's taught my Sunday school class for 22 years. I would have hugged her, paid her, whatever is necessary. And the next question was, well, if the evidence as it comes to you from the witness stand and the judge as he gives you the law was against Mr. Morris, would you rule against him? And she said, no, I couldn't rule against him. I know he's on the right side. Now, not only did I slam dunk the baseball fellow over here, but this marvelous lady is telling the whole jury, I'm just sanctified. That's what's called voir dire. That's what's called jury questions. That's the kind of questions that are asked that they want to know information about you. But as I say, there are no right and wrong answers. What kind of jurors are chosen? Pretty decent question. What kind of jurors? What is the plaintiff looking for? What is the defendant looking for? The defendant, by and large, and this is stereotype, and I promise you it's not correct, but generally, the plaintiff is looking for blue-collar, working people, people that not in the upper income level, people that would want to see the underdog prevail. What is the defendant looking for? The defendant is looking for conservative, elderly. Truthfully, when I first started practicing law, they were looking for people who had been through the Depression, who were just by nature inherently conservative. That would be one of the questions that would ask. Were any of you born or reared or remember the Great Depression? Because apparently, and I think the good Lord, I don't remember it, but it must have been tough, because the ones that had been on my juries that had been through that Depression, they didn't want to give me nothing or give my client anything. So generally, that's what the plaintiff is looking for. That's what the defendant is looking for. And out of that, the ones who get chosen. Now, let me tell you who they are. I had this great guy, one of the best friends, been in the furniture business. He wouldn't give 5 cents to watch a rattlesnake ride a bicycle. He's just the most conservative individual I've ever known. But he's a dear, dear friend of mine, and he sits up there on the panel out there, and he gets struck. He's the first one struck. Every time I'm just striking him, coming, I wouldn't have him. He gets his feelings hurt. Finally, he walks up to me and he said, "Larry, what is it about me? I've been here for 2 weeks. I ain't got to serve on a jury." I said, "Austin, that's good. It speaks well of you." He said, "Why is that?" I said, "Well, you got to figure. I didn't want you. I wouldn't take you. I knew you wouldn't award anybody any money. And so you're over here on this side, and I strike people like you, and they strike people over here on this side who would be inclined to award an awful lot, and you end up with the people in the middle that never respond to a question. The truth be known. They've never been in a lawsuit. They've never been in a courtroom. They've never sued anybody. They've never been to try to collect any money from anybody in small claims courts. They've never done. It's the people that hadn't answered one question that was asked. I think you agree with me, Alan. That's about what the juries you end up with. It's not the people on the far right, not the people on the far left. It's the people there that you'd think they've lived in a vacuum their whole life. They ain't answered nothing. But that's who usually the jurors, what juries are consist of, and it's good because it's usually a middle-of-the-road, fair jury, and that's really all any of us truthfully can ever want. Let me share some things that a lawyer can't do. I'm skipping around on the outline. I don't care if you can't follow me. That's all right. You can't stand before a jury and say to the jury, "I represent Ms. Wheeler, whose son was killed in a car wreck, and if it were your son, how much money would you pay?" You can't ask the jury to step into the shoes of either the plaintiff or the defendant. Because let's face it, everyone in here would give everything they have for their own child. That's not the test. The test is, under these set of circumstances, what is a fair and adequate award here? So a lawyer cannot, and if he will be reprimanded or should be reprimanded by the judge if he asks you to step in to the injured party or the corporate party's shoes. That's a no-no. In certain instances can give rise to a mistrial. So you'll see on TV a lot of times, you'll see when they're having these trials or in the movies or something, and they'll say, you know, what would you do if it was you can just remember that's not going to be asked in a courtroom, not in a real courtroom. You can't ask a witness who is not a, quote, expert to guess or to speculate. How far was it when you first saw the approaching automobile? Well, I guess it was no, you can't guess, objection. Well, I really don't know, but I would speculate that it would be about, no, you can't do that. You can't guess or speculate. You can give your best judgment, which is maybe a play on words, but it is the law. That is, you can't ask a layman to guess or speculate. Well, in my judgment, he could have stopped. Probably couldn't get that in. You sure couldn't say, shoot, my best guess is he should have stopped. We know that's not admissible. Should have seen him, particularly if he's not an eyewitness. Now, what's the exception? You can do it with expert testimony. Who is an expert? Well, they always say an expert. I'm an expert tonight. I'm further than 50 miles away from home. And I can tell some big ones if they weren't taping it back there. But an expert is a person who possesses knowledge beyond what an average, normal layperson would possess. An accident reconstructionist, a medical expert, he can give his opinions. Laymen cannot give opinion testimony. That is, speculation or guess. What they see, what they observe, they can testify. We know that's called an eyewitness. But they cannot, but a layman is bound only to what he's seen or have observed, what he knew or what he heard. Facts, hard facts. Experts can give opinions. So what do? We go out and hire experts on one side. They go hire experts on the other. Jury sifts that out. Which expert's better? Which expert's more believable? Which expert gave me facts upon which I can base a solid opinion? So that oftentimes in complicated litigation, such as products cases, most any case nowadays that's involved with a lot of lawyers, we get experts. And it's tough for a jury to understand the technical language, but so often that's what it's based upon. The difference between federal court and state court. Believe me, I love state court. I'll tell you why in federal court. They have this little thing about like this. You can't walk around in federal court. Most federal courts are like this. You've got to stay behind the lectern. You're over here with a witness. You got a witness stand. In state court, we're up here. We want to talk to them. We know as lawyers, the closer you get to an individual, the better chance you have of getting the truth. In federal courts, you're going to stand right here. You stay behind this lectern. State courts, you can walk up to witnesses. You can walk over to juries. One of the greatest courthouses down in South Alabama that I love more than anything. The witness stand is right here, and the jury box is right here, and there are no barriers between them. That witness is standing out here naked. He has no protection, and this is protection between me and you. I'm just telling you that. We all know that. Lawyers know that. Any barrier between you gives people comfort levels. And therefore, if you don't have this, then hopefully at the end of the trial, then you want me to come sit in your lap. One of the great stories I ever heard one time is by a lawyer in West Virginia, and he says, if a lawyer is doing his job, you start out and you never crowd the jury. And you stand off when you first start. And as the case progresses, you ought to be able to get closer where they accept you more. And at the end of the case, if you've done your job, you can take your leg and put it over the rail and sit in the jury lap. Now, I may be stretching it, because I think that is another thing the judge will put you in jail for. But you know what I mean, and what I'm saying is that the difference in federal court that I don't like is very stolid and it's very proper, and you stand behind this lectern and you cannot move. the last case I tried, and I saw Ed Harden walk in. He'll know what federal judge it is. It's a stickler for it. But I got to the point after the 4th day that I was over here doing this, still claiming I was standing behind it because a witness was not doing right. And I was getting kind of heated about the thing, and the judge kept saying, Mr. Morris, get behind the lectern, Mr. Morris. Well, there ain't no justice in that, I don't think. I think you ought to be able to go up to the witnesses and just share, and let me show you this document. How can you say that? One of the big things, another thing is arguing that lawyers make terrible mistakes. And I can promise you, juries will respond and they will slam dunk you. And that is arguing large numbers to a jury without any justification for the numbers. I remember there was an older lawyer when I first started practicing law that was telling me about this other older lawyer he didn't like in another county. And he said, that's the only lawyer I have ever seen that will stand up and beg a jury to bring in $800,000, and when they bring him back $7,500, he doesn't think he won the whole world. And my point is, a jury, if you're going to ask a jury, invade their privacy enough to ask them for a verdict of X number of dollars, you better have the evidence and numbers to back it up, or they will slam dunk you, and they should. Another thing that occurs, two things that occur, and I think you'd learn pretty quickly, is one, you don't argue with the judge. You hear, I saw some movie the other day that Paul Newman was in, that where the other opposing counsel was just arguing hard with the judge in front of the jury. Now, you argue before a judge when you have all these motions, but one of the no-nos as far as a courtroom is you don't argue with the lawyers don't argue with the judge. Secondly, you don't argue with your opposing counsel. If you're going to be sitting over here, you all would judge, I object to this lawyer doing this. You announce it as judge. You don't address the other lawyer. You don't get the back and forth between the two lawyers. Does not happen in a courtroom. It should not happen in a courtroom. One of the things that has happened, and I made a terrible mistake, I'll tell you this true story. I usually say after a trial has been going 10 days or something, I'm usually the last one that gets up to speak, and I will say to the jury, ladies and gentlemen, you've heard enough of me talk. And you can just think how I've worn y'all out in the last 45 minutes. You think about 3 weeks of me. You had all you can handle, you know. So I'll say to the jury, ladies and gentlemen, you've heard enough of me. This is the last time you'll hear from me, but if any of you want me to sit down, you just raise your hand, I'll go sit down. I've kind of used that through the years. I never had any takers too much. About 6 months ago, I'm trying a case down in southeast Alabama. You could sit in the courtroom, the jury room. The jury was right over here where this, like that window, and there was a series of windows out there. And I got up, and I thought it was a very serious case. Apparently the jury didn't think it was too serious, but I thought it was very serious, and that demanded an awful large verdict in the case. And so I get up, and I start talking and closing the argument and said, I appreciate your attention and so forth, but let me tell you what this case is really about. And I had already told him, if you get tired of listening to me talk, then you just raise your hand. So I had been up about 3 to 4 minutes, and I looked back there, and this lady's just doing this right here. So here I am. I can't talk anymore. I done told him if she's tired of me now. So I go over there and I said, thank you, ma'am. Ladies and gentlemen, thank you. And I go sit down. She says, no. She said, I want to hear you talk a long time. Boy, if you don't think that helped my feelings. She said, I want to hear you talk a long time. But this fella, I didn't have my jury pass down here, and the police are giving me a parking ticket down here on my car. Judge, can I have about 5 minutes? And sure enough, the judge was laughing by this time, and because I don't think he'd ever seen it, scared me to death. And he allowed the jury, but I had a flavor that I was hoping she was speaking for everybody else, and she seemed to have done that at the end result. Let me share one thing about when you do choose an attorney. And believe me, the attorney is working for you. When you choose an attorney, you've hired somebody to do work for you. You don't need to be intimidated or don't need to feel like, well, I don't want to call him. But let me tell you some things that you need to know about keeping up, because I promise you, lawyers do not like to be called every 2 days to see how your case is coming along. I'll tell you that. But on the other side of the coin, you have every right under the sun to know how your case is coming along. The timetable generally on any case is filed is the fact that you file it, then 30 days goes by and nothing happens, and then the other side files an answer. And then after probably about 60 to 90 days, they take your deposition and we take the defendant's deposition. So that'd be your first involvement in a case. Then it's usually about a court docket nowadays in most counties, and I think this is true, you would generally get to trial, or should get to trial, between 9 months and a year. You're not talking about the 4 or 5 years that you hear about in Cook County, Illinois. The cases in Alabama move. The cases in Alabama should, because justice delayed is justice denied, and there is no question about that. So you should be able to get to trial within a reasonable period of time. One of the things that you would call your attorney is to call him and say, send me a copy of when I give my deposition, send me a copy of my deposition and send me a copy of other things that you think are pertinent. I promise you lawyers will do better in life, and I'm talking about myself too, if in fact we would keep you informed through documents, things we get in the mail, just send a copy of them. And we do that, we try to do that. But one of the things, the other thing I would say about your attorney and choosing an attorney, and I mean this as sincere as I can do that, can say that, is this. If you're not comfortable with that attorney and he's not comfortable with you, you're not going to get a result. I don't know any other way to say it. And it's nothing against the attorney, and it's nothing against you. But all lawyers can tell all the stories, but I knew that for this particular client, I was never going to have a good result. She walked in the office, a Miss Smith, let's say. Miss Smith, tell me, I know how the wreck occurred. Are you hurt? Oh my God, oh, am I hurt? It's awful. Well, what's awful about it? And she proceeded to tell me, and basically I knew at that point in time it made no difference whether the verdict was $500,000 or $5 million, she was never going to be happy. I couldn't satisfy her, and she wasn't real happy with me because I was telling her, you've got to be realistic. You've got to be realistic. So I say to you, to each of you, you're the one who chooses the attorney. If you're not comfortable with that attorney, if you're not comfortable with his attitude toward your case, then you don't need to hire that attorney, and he would tell you, if he's worth his salt, he would tell you the same thing. I have on my desk right next to the telephone, it's just my favorite thing, and y'all have been kind enough to listen to a dysfunctional, off the board, around the world, but y'all have already been educated before you got to me. You've heard about products liability, and you've heard about medical malpractice, you've heard about car wrecks, you've heard about real estate. The truth be known, there's a lot of areas that y'all have heard about, that y'all had lectures on, that y'all are a lot better lawyers than I am about it, and that's not saying much. But somebody asked me coming in, they said, do you do divorce work? And I said, if I did, it's malpractice. So I don't know anything about them. I don't know how, Lord, don't let me go look up a deed and try to tell you where you got good titles. So y'all know about segments of the law a lot more. Law has become very specialized. Law has become very much like medicine. Our firm only does personal injury and suits against companies that we feel like have mistreated and done people wrong. That's all we do. It's simple. You come in there with a criminal case, I don't even know what the law says on crimes anymore. But I do know this. You check your lawyer's attitude. On the telephone, right next to my telephone, is my favorite saying, and I'll share it with you and I'll close with it. The longer I live, the more I realize the impact of attitude on life. Attitude to me is more important than facts. It is more important than the past, than education, than money, than circumstances, than failure, than successes, than what other people think, say, or do. It is more important than appearance, giftedness, or skill. It will make or break a company, a church, a home, a person. The remarkable thing is we have a choice every day regarding the attitude we will embrace for that day. We cannot change our past. We cannot change the fact that people will act in a certain way. We cannot change the inevitable. The only thing we can do is play the one string we have, and that's our attitude. I am convinced that life is 10% of what happens to me and 90% of how I react to it. And so it is with you. We're all in charge of our attitudes. I want to tell you it's been my pleasure to be with you. It's been my pleasure to share some things that are true, that are somewhat humorous perhaps, because if you can't laugh at yourself and if you can't laugh at what happens to you in the courtroom, you don't have much of a sense of humor. I congratulate Alan, Charles on the splendid job they're doing, and I trust that you've learned something from these series of lectures. I doubt very seriously if you learned one thing from me tonight, but I enjoyed talking with you. Thank you.
I know that you have attended more than one People's Law School, and I would like to ask you why you attend.
Oh, I always like to learn something, and I learn something new every time I come.
Well, and you're a physician here in Huntsville, but you feel like you'd like to have some knowledge concerning the law.
Sure, everybody in the whole city, the whole country, needs to have some knowledge of the law. It affects you every day.
Has the People's Law School been, did it meet your expectations?
Yes, it did. It's quite practical information.
And you've heard, I think, been here for 13 weeks, the last class?
Something like that.
And hearing a couple of lawyers in each class.
At least two.
And you feel like you've learned something that you can use in everyday life?
Oh, certainly.
I want you to tell me why you chose to attend People's Law School.
I am a nursing instructor at Calhoun Community College, and I've been there for a long time. And the legal system is a part of the work that I do. Our students must follow a law set forth by the Alabama Board of Nursing. And it's part of my teaching responsibility to do that. And then I have my own private consulting business. And I do medical records. I'm not an expert witness, but I do review medical records for attorneys, for insurance companies. And I need that knowledge.
Well, did it meet your expectations?
Oh, it did. See, I was here last year.
Well, so this is your second term.
So this is my second one. So certainly, if I'm here twice, I have to be smart enough to get something from it.
All right. Can you think of anything generally that you've learned that you feel will be of help to you in the future?
The medical malpractice was exceptionally good, and we have that tape. And we have had the privilege of showing it to the students, plus encouraging them to watch other sessions of the tapings.
Okay. And if you have the opportunity to advise others in this community as to whether or not they should attend the People's Law School, what would you tell them?
Oh, I would certainly encourage them to attend. As a matter of fact, this summer I sponsored a legal workshop for the Alabama Nursing Association here in Huntsville, and 4 of the attorneys came and gave of their time to speak to the nurses there. And I hit Alan up for a door prize of a scholarship fellowship for the law school, and he gave me that. So that nurse has been here too. There have been 4 of us that were at that session that came as a result of Alan being there to speak.
I came because my neighbor was afraid to drive down here by herself. So I came with her, and then after I came, I decided I'd enjoyed it so much that I'd pay and take the class too.
So you signed up and have been attending ever since then?
I missed one.
And you got your certificate tonight.
And I got my diploma.
Got your diploma, so you graduated. Now tell me what you feel like you might have learned out of any of these sessions.
Well, the main thing that I feel like I got out of it, that I can talk to a lawyer without being afraid of him.
Would you recommend that to other people in this community attend the People's Law School?
Yes, yeah. I think it would help them. I think really the reason that I came is that I'm getting old, believe it or not, and I feel like that the more that you use your brain, the longer you'll have it, and that's one reason.
Keep learning. Tell me why you chose to attend People's Law School.
Well, I saw the little ad on TV the day it was to begin, and I thought, that sounds interesting because there's a lot of things you don't know. And I called up to see if the class was full because you had to be pre-registered by a certain date, and it was past that date. And they said, no, just come. So I did, and I talked Mamie, my neighbor, into coming with me that night, or I told her I was going to do it, and she said, well, I'd like to go with you. And so she ended up signing up also, and we've thoroughly enjoyed it. It's been very interesting and educational, you know, pick up little things you never knew before.
Would you recommend it to other people?
Oh, yes, very much so. It, as I say, was interesting and fun, and you learn a few things that might be helpful someday.
Did you learn a few things about a few lawyers?
A few lawyers, yeah.
You enjoy the speakers?
It was a nice group. It really was. I was impressed by, well, just every one of them. And some were funny and some were serious, but, you know, you kind of get an overall picture of what it's like to be in the legal field.